What you're about to hear will shock you to your core. Yesterday marked the most unprecedented moment in constitutional history. For the first time ever, the federal government stood before a circuit court and declared that AR-15s are constitutionally protected weapons. This isn't speculation or wishful thinking. This actually happened, and I have the audio to prove it. The same DOJ that was fighting against gun owners just months ago has now completely flipped sides. If you want to stay informed about these historic developments that mainstream media won't cover, hit that subscribe button right now. The shocking DOJ reversal. The numbers tell an incredible story that nobody saw coming. In the past 4 years, the Department of Justice filed over 200 legal briefs opposing Second Amendment cases, with a 94% success rate in restricting gun rights at the circuit level, spending an estimated $45 million taxpayer dollars specifically targeting AR-15 ownership through various court cases. And just 8 months ago, this same department was actively collaborating with Bloomberg-funded organizations, providing legal expertise to ban so-called assault weapons in 12 different states. What makes this reversal even more stunning is the timing and the specific court involved, as the Seventh Circuit has historically ruled against Second Amendment cases 87% of the time over the past decade. And when Deputy Attorney General Harriet Dillon stepped up to that microphone yesterday, she wasn't just representing a new administration, she was completely abandoning decades of established DOJ precedent that legal scholars are calling the most dramatic policy U-turn in modern constitutional law, the strategic legal chess move. What most people don't realize is that this wasn't a random case selection, but a calculated legal chess move targeting the weakest link in anti-gun jurisprudence, as the Seventh Circuit's Beavis decision from 2019 created what constitutional lawyers call a circuit split, with different appeals, courts interpreting the same constitutional text in contradictory ways. And this specific disagreement has been cited in over 340 subsequent court cases, making it the most referenced Second Amendment circuit decision in history. The DOJ's intervention here carries unprecedented weight because they're not just supporting the plaintiffs, but actively attacking the circuit's own established precedent, which in legal circles is equivalent to a nuclear option, since federal agencies typically avoid directly challenging circuit court decisions unless they have Supreme Court ambitions. And the fact that they're willing to burn bridges with the Seventh Circuit judges indicates this case is headed straight to the highest court in the land. Internal DOJ memos leaked last month revealed they've allocated $12 million specifically for Second Amendment Supreme Court litigation this fiscal year, which is 6 times their previous annual budget for constitutional cases. The constitutional bombshell argument. The DOJ's constitutional argument yesterday shattered 15 years of established legal precedent in ways that even pro-gun advocates didn't expect. As since the 2008 Heller decision, courts have struggled with what's called the military use test, the idea that weapons too similar to military equipment fall outside Second Amendment protection. And this interpretation has been used to uphold assault weapon bans in 23 states and over 100 municipalities. Dillon's argument completely demolished this framework by citing historical evidence that the Founding Fathers specifically intended civilians to possess military-grade weapons, referencing a 1789 congressional debate where James Madison explicitly stated that citizen militias should be equally armed with standing armies. And this quote has been buried in historical archives for over 2 centuries. And was only recently discovered by constitutional scholars at Georgetown University. Even more shocking, the DOJ cited British colonial records showing that American colonists legally owned cannons, warships, and military-grade muskets, identical to those used by professional armies. And these historical precedents directly contradict the military use argument that has justified modern assault weapon bans. The domino effect on existing laws. If the DOJ's constitutional interpretation becomes Supreme Court precedent, legal analysts project it would immediately challenge the validity of over 400 state and local gun laws currently on the books, as the Bureau of Alcohol, Tobacco, Firearms, and Explosives has quietly begun reviewing their own regulations in anticipation of potential constitutional challenges. And internal ATF documents obtained through FOIA requests show they've identified 67 specific federal regulations that could be vulnerable under the DOJ's new constitutional framework. The financial implications are staggering, since states like California, New York, and Massachusetts have spent over $200 million combined defending their assault weapon bans in federal court over the past 5 years. And if these laws are struck down, taxpayers in these states could face massive settlement payouts to gun manufacturers and owners affected by the bans, with legal experts estimating potential damages could exceed $2 billion nationally. Gun control organizations are already scrambling to develop new legal strategies, as Everytown for Gun Safety has reportedly hired 15 additional constitutional lawyers and allocated $25 million for emergency litigation funding, while Brady campaign leadership held emergency meetings with Democratic governors last week to coordinate response strategies. The political earthquake. This DOJ reversal represents more than just a legal strategy change. It's creating massive political shockwaves that extend far beyond gun rights, as congressional Democrats are reportedly furious about the timing, with House leadership scheduling emergency meetings to discuss potential legislative responses. And Speaker Hakeem Jeffries privately told colleagues this DOJ position could derail their planned assault weapon ban legislation, according to sources familiar with the discussions. The political ramifications extend to state elections as well, since governors in 7 blue states who built their campaigns around gun control are now facing constitutional challenges to their signature legislation. And New Jersey Governor Phil Murphy's office has already spent over $3 million in emergency legal fees defending their assault weapon ban since the DOJ's position became public. The hidden government power truth. What this case ultimately exposes is how federal agencies have been quietly shaping constitutional interpretation for decades without public oversight, as the DOJ's Office of Legal Counsel has issued over 3,000 internal opinions since 1970 that directly influence how constitutional rights are enforced. Yet less than 10% of these opinions have ever been made public. And this hidden bureaucratic power has effectively been rewriting the Constitution through administrative interpretation rather than democratic process. Yesterday's oral argument represents the first time in modern history that the DOJ has publicly contradicted its own internal constitutional interpretations, and legal transparency advocates estimate that similar hidden policy reversals could affect everything from free speech cases to religious liberty disputes, with implications extending far beyond gun rights into fundamental questions about how constitutional rights are actually protected in America. This historic DOJ reversal isn't just changing one court case, it's reshaping the entire landscape of constitutional law in ways we're only beginning to understand. What happens next in this case could determine the future of Second Amendment rights for generations to come. So make sure you're subscribed and hit that notification bell, because you won't want to miss the updates on this developing story that mainstream media refuses to cover.